She's basically grasping at straws here to try to continue to move forward, and numerous attempts to try to take our daughter away from me. A lot of this stuff has been done vindictively on her part. Is there any way to limit the number of times I have to defend myself in this stuff?
We are here today for an evidentiary hearing on a motion filed by Ms. Fisher to request a change in custody. Ma'am, just briefly, what custody change are you seeking to make?
Well, originally I was hoping to have majority custody with him having standard parenting time. But since our last hearing, I have received some other evidence of him being abusive towards both his wife and his child.
All right, so does that mean your request is different now?
Yes, Your Honor. So I'm now requesting to have full legal custody due to a concern for the safety of my daughter, Rogue.
And what about parenting time?
At this time, I would think supervised.
All right, thank you. Mr. Mogenberg, are you in agreement with those requested changes or not in agreement?
I'm going to go with a hard no on that. That's pretty unreasonable.
All right, thank you. So what we will do then is move forward with the hearing. We've had hearings before in this matter, and back in February of 2022, there was a motion that was dismissed for lack of proper cause or a change of circumstances. Ms. Fisher, what is the current parenting time that is being exercised?
We have 50-50, a week on, week off.
Doing week on, week off? Okay. Because I saw a mediation agreement at one point that had a schedule that was different. It was like a 2-2-3.
Yeah, 3-4-4-3, I believe.
How long have you been doing the week on, week off?
I would say a few years now.
Okay.
It's been a while.
All right. So what I indicate for both parties is, anytime an order is being changed, you have to show proper cause or change of circumstances. We look to the last order. So there was a request to make a change back in late 2021, which was heard in early 22. So the events, what we're looking at then is what's happened moving forward since that time, since those issues that occurred before that time already had a chance to be litigated. We're not going to relitigate those issues. So the parties need to focus their arguments based on moving forward. So 2022 up until today's date is really the evidence that the court is looking at to determine if there is proper cause or change of circumstances, and then what should be a change, if any. All right, Ms. Fisher, is your motion, so you would go first. Do you want to testify yourself, or do you have a witness to call?
I'm testifying myself.
All right, please raise your right hand.
I do.
All right, thank you. All right, man, this is your opportunity then to provide testimony in support of your motion.
He was evicted. He's been evicted now twice. He lied about it. It was about, I have the dates. He was evicted from Kristen Lappin's house. He lied about it. They told me that they had found a new home and that their lease was coming up, but they were actually evicted. So that was my first reasoning. And then they did recently have another pending eviction in the house that they're currently living in, but it appears that they've resolved that. I'm not sure exactly what happened. They owed almost $10,000 on it. Since then, the reasoning though that I have changed my request though is I have received a video from Jody's ex-wife, Paula, who they were living with. I have submitted the video for evidence as well, and it shows him attacking his wife, strangling her. It shows her then harming herself, and him proceeding to attack his daughter, his 12-year-old daughter at the time.
And when was that video made, ma'am?
That video was in 2020. it was shown to both CPS and the police, but they said that I spoke with the police after I received the video, and they said that the charges were dropped for some reason. They couldn't tell me why. For this, but I'm still given what I've seen on the video, I'm still very much concerned for the safety of my daughter.
Individual in the video with him that you're saying was Paula Feccio, is that correct?
Yeah. She sent me the video. She was not in the video. It was recorded in her home because she has cameras inside of her home.
And who was it that you're saying Mr. Mogenberg was attacked?
Mr. Mogenberg attacked his wife by strangling her. He then attacked his daughter, who was 12 years old at the time. And then he attacked his wife a second time, throwing her down the steps after she harmed herself in the kitchen.
And you're saying that's the individual he's currently married to and residing with?
Yes.
All right, thank you. You might have some evidentiary issues with this video, though. You did not film this video, correct?
I did not. Paula sent it to me, hoping that I would be able to use it to get my daughter out of that situation.
And when did you receive it?
I received it in March.
But the video is 3 years old?
Yes. There was a CPS investigation, and I was aware of the situation with his wife harming herself, but they did not tell me about anything about him abusing his daughter as well.
Okay. Anything else, ma'am?
I do have the video that I can show.
Well, I'd ask Mr. Mogenberg if he has any objection to the video.
Yes, I do have lots of objections to the video. The video was, it was intentionally left out the audio because my ex-wife has audio on her cameras, and I believe it's in some way a form of evidence tampering, because the audio was actually what cleared everything and made sure that I was not in trouble. And the fact that Ashley is submitting something that has the audio intentionally left out by my ex-wife, who has open CPS investigations against her right now and is using the video to try to use as revenge, is a big deal. And not to mention the fact that Ashley has had this video since the day after the incident happened. My ex-wife sent that to Ashley's mom and to Ashley as well. This is not new information. This is information that she's basically grasping at straws here to try to continue to move forward, and numerous attempts to try to take our daughter away from me. So I don't believe that video is relevant. I don't believe it is anywhere near current. She has had this video for quite some period of time, and it's something that I was never charged with. There was never any issue with, and I dispute what she's saying even happened in the video.
All right, thank you. So at this time, I'm not going to admit the video for a couple of reasons. One is the age of the video. Another is the chain of custody of the video. We do not have an individual to come in to verify that was an accurate depiction of the video, that then how video was recorded, and then how it was disseminated. We just have Ms. Fisher indicating this video was provided to her. We do not have the individual who was responsible for the video to testify regarding the creation of the video, the accuracy of the video, and the chain of custody of the video. So I'm going to grant the objection to admitting the video as evidence. Ms. Fisher, do you have anything additional?
I would just say the video does very clearly show him punching his daughter in the face.
There is no way that is true. So her statement.
So I've ruled that the video is not coming into evidence, ma'am, so I'm not going to, your interpretation of what you saw in this video then is not going to be admitted as evidence. It does sound as if there was CPS involvement at the time also. So I'm not going to let you testify as to what you saw in this video.
So proceeding forward, if I was able to have Paula testify to that, would I be able to then show that, or have other witnesses who were there at the time?
I can't guarantee what would happen if other people testified, but certainly there is proper procedure to authenticate videos and evidence. And I
Okay.
don't believe I have that here for today's hearing.
Okay. Is it possible to reschedule it for a further time that I can have that happen?
Mr. Mogenberg, do you stipulate to adjourning this matter, or do you object to adjourning this matter?
I object to it because this is something that not only is what she's talking
That's
about
all I
happening.
need, sir.
All right, thank you.
We don't need to get, all right, so I am not going to adjourn this matter. We've had this hearing set. Plenty of time to secure any necessary witnesses to provide evidence in this matter. Any other testimony you want to provide, ma'am?
No, thank you, Your Honor.
Do you have any witnesses that you want to call?
No, not at this time.
Mr. Mogenberg, you do have the right to ask Ms. Fisher questions. This is her motion, so the first hurdle for her to get over is there a proper cause or change of circumstances? Do you have any questions you want to ask her regarding those issues, or do you simply want the court to then take some testimony from you, or maybe not even testimony from you, and then make a decision on that proper cause or change of circumstances?
I do not have any questions from her, but I would like to give testimony when it's time.
Would you please raise your right hand?
There has been no change in circumstances. We've actually, our situation is improving every day. The rogue is very well cared for between both parents, and rather than bring up stuff and try to submit evidence and everything, I'm just trying my best to establish grounds that a lot of this stuff has been done vindictively on her part, and I don't know whether there's such thing as co-parenting classes or things to help make it to where these attacks and these attempts can cease, because this is the second time that she's tried to do something. Over Christmas, when I was incarcerated for a short period of time, she kept Rogue away from her sisters. She kept Rogue away from her stepmom, and that's really, really difficult for my middle daughter Parker, my oldest daughter Cassidy. They have had a great relationship with their sister, and I think that these constant attempts to keep Rogue away from myself and my family, and especially Rogue's sisters, is pretty detrimental to Rogue's development and Rogue establishing bonds with her family. I've never tried to do that to Ashley, and actually at this point I'm even refusing to bring up anything else of the evidentiary stuff that I had submitted, because I don't think it would serve any benefit other than to continue to cause ill will between us. So if there's a way to, I don't know if there's really a way to order parenting classes or whatever it may be, but I would like to just find a way to put this behind us and get along and remember who the most important party is and whose best interest is in mind is Rogue's.
All right, anything additional, sir?
No, that's it. Thank you.
Ms. Fisher, do you have any questions for Mr. Mogenberg based on the testimony he just gave?
No, I don't have any questions for him, Your Honor.
Well, I think the first step is to determine if there's proper cause or change of circumstances. I think now would be an appropriate time to make that decision. Again, as indicated, the parties had a prior order. There was a request to change custody in late 2021, early 22. There was a decision at that time that there was not proper cause or change of circumstances. Based on the evidence today and the testimony today, since that last court hearing, I do not believe there has been a showing of proper cause or change of circumstances. There was testimony regarding evictions. However, there was no evidence or proof that even if Mr. Mogenberg was evicted, that there was any living conditions provided to the minor child that would warrant readdressing the best interest factors. The fact of being evicted alone is certainly not enough to rise to the level of proper cause or change of circumstances, as long as there continues to remain appropriate housing. There was some testimony, however, this video was not admitted into evidence, but it does appear there was a CPS investigation as well as law enforcement involvement, and that incident was several years old. So I do not find there is proper cause or change of circumstances. So it is my recommendation that the motion be denied. The parties do have the right to object within 21 days. That information will be provided in the written order that is sent to the parties. Ms. Fisher, do you have any questions?
No, Your Honor.
All right, Mr. Mogenberg, do you have any questions?
Since this tends to be a recurring issue, is there any way to limit the number of times I have to defend myself in this stuff, in these type of cases, or is this something I'm just going to have to continue to deal with?
Well, I mean, certainly if frivolous motions are filed, you have the right to seek costs and fees that you may have. I'm not going to order anything like that based on this motion, but there are obviously options out there depending on what happens in the future. I would indicate to both of you that obviously co-parenting is highly important. I'm not going to order a class, but there are classes out there that perhaps the two of you would benefit from. So if that's something you agree to do, you can certainly do that. It probably would be in the best interest of your child to find a way for the two of you to communicate appropriately and co-parent together appropriately.
Thank you.